Just waiting here a moment for people to show up. Good morning or good afternoon, everyone. Welcome to our webinar on the Great Transatlantic Data Disruption. I'm Mike Mandel. I'm the Chief Economist and Vice President of the Progressive Policy Institute. We're a DC-based think tank. We've been around about 30 years, working on issues on growth and innovation, not just in the US, but globally. I'm joined here today by Christian Stout, Director of Innovation Policy for the International Center for Law and Economics, and Jose Lee Makiyama, who is the Director of European Center for International Political Economy. And we're going to have a nice discussion about the prospects for cross-border data flows being interrupted, what's been happening and why, and what we might do about it, if anything. And we'll see if we come up at the end positive or negative. Feel free to sort of ask questions along the way, and we'll try to address them too. What I'm going to do is I'm going to give a quick sort of summary of where we are, and followed by Hosek and Christian. And Hosek, you know, if you hear me say anything that you think is wrong, please feel free to interrupt. Okay, don't hesitate.
I would never do that. I just interrupted you.
Okay, so where are we at this point? We, you know, as people probably know, there's enormous flows of data across the Atlantic, back and forth, and the legal basis for this has been in question. And the key decision was the Schrems II decision that was taken by the Court of Justice of the European Union in July 2020, where they declared that the Privacy Shield, the mechanism for transferring personal data between the US and the EU, was no longer lawful. The decision left in place, at least for the moment, standard contractual clauses as a mechanism for transferring data that was still allowed under the GDPR. But the problem is that the same grounds that were sort of used to invalidate the Privacy Shield, which is the exposure of EU citizens to US national security surveillance, is still true for the standard contractual clauses. So that there's the issue going forward that there may be decisions in particular by the Irish Data Protection Agency, okay, that invalidates standard contractual clauses as well. And the question is, what is going to happen? What does this mean? What can be done? Is this a tempest in the teapot, or is this an existential crisis? This is kind of falls on and off the radar, both in Europe and in the US. It's recently been brought up again by the decision of the Austrian Data Protection Agency that a website that was using Google Analytics was violating GDPR because Google Analytics was transferring data to the US. Now, the website was in violation, but not Google. But this potentially calls into question a lot of uses of US cloud services in Europe. Now, Christian and I and a co-author wrote a paper on the Great Transatlantic Data Disruption back in October. It's on both the PPI website and on the ICLE website. Take a look if you're interested. We brought Hosek on board here to talk a little bit about this from the European point of view, because what is fascinating here is that at least from our perspective, Americans kind of ignore this because they assume that that it's so important that this problem will be solved. And the Europeans are not so sanguine about this. So, Jose, why don't you step in at this point?
Well, thanks. And before I start, let me congratulate you to a very succinct and very timely report, especially considering what has been announced this week from Austria, that Google Analytics is can no longer use standard contract clauses to transfer data to United States. And so, first of all, big congratulations. I urge everyone on this call to actually join and read the report. I think it's a very good summary of what's going on at the moment. But I think you do have a very good point that the perspectives in Europe is slightly different. You have to also remember that it's not just a question about is this an economic issue or is it a fundamental rights issue. You also need to remember that actually it has now been, well, it's going on to 4 years until the final implementation of GDPR. We've been living with this for a certain amount of time, and therefore this has become something of a baseline in a way that I think most Americans are not really accustomed to, I would say. There is a certain level of not just acceptance, but also adaptation that this actually, this law from a perspective of a number of reasons, not just economic, but also political, and from the perspective of fundamental rights, this was let's put it this way, the right response to a huge amount of political capital that was available at the time. I'm not sure if I answer your question, Michael, but certainly you do have a point that the views are slightly different here.
Well, I think that's really important because, I mean, my sense is that, as you say, for many Europeans, this is a settled question. For many Americans, it's something they haven't even thought about. Right? The U.S. has no national privacy policy as such, right? And companies have adapted to GDPR, but not in the legal sense, just in the business sense. Okay, that their adaptation has not actually taken care of the objections that the European Court has to the data transfers between US and Europe.
Very true. 2 points that I would just add here, Michael, if I may. First one is that we are used to regulatory adaptation. I mean, we are used to regulatory compliance. Some people would even argue that one of the comparative strengths that a European multinational has is actually regulatory compliance. The more complex a market is, as long as it is predictable and there is rule of law, actually, we like complex markets because that actually gives us a huge comparative advantage against American and Chinese firms. And so there is a cultural aspect here. I mean, if you think about the number of companies in Europe that are adapting to ISO or business regulations and practices, and in addition to mandatory ones, you will see that there is a different tradition when it comes to certification and compliance issues in Europe. That's one thing that comes to my mind. And also, I mean, the idea that Europe is not that competitive when it comes to platforms is certainly a point that is still valid today. We don't have a major platform that deals with personal information, and one of the aspects of GDPR is that it's not a two-way street. In other words, GDPR and the Chapter 5 on transfer mechanism mainly deals with taking data out of Europe. Europe's offensive interest in taking data out of another jurisdictions was never really affected. So, you do have a very good point there as well.
So, I mean, Christian, we'll get to you in a second. I just want to ask Jose one more question. But it's not possible for U.S. multinationals to adapt to this because the objections that the European court has is rooted in U.S. national security and the way that things are done that way. So you can't actually get around. This is not something that companies can decide that they're going to fulfill what the court wants. This is something that would be required to be done at the national level.
That's absolutely right, because I think there is some degree of misconception here that the American multinational is at trial. That is not the case. The ones that is trial is in the first term cases. First was foremost, it was actually the European Commission for signing a treaty with an adequacy agreement with the United States. So it was actually not about a company practices at all. And if you look at the Schrems 2 case, it's primarily about the safeguards available under US law, whether they were actually adequate in combination with the efforts that have been done by the corporations themselves. But as a totality, does the US Cloud Act and FISA have the potential to breach European fundamental rights and GDPR? That's the essential bottom line question, I think.
So Christian, okay, one of the things that we did in this paper is we actually talked about what could be done, right, to actually move past. We have a situation now where, as Joseph describes, is that there's a gap.
Right.
It's hard to quite see how to sort of fill the gap.
Right. I am an eternal optimist. I think the point that you just made is correct, that this is not fundamentally about US firms needing to comply with a regulatory state and chafing about that. I mean, sometimes that happens. That's not what's going on here. What this is fundamentally a foreign policy or trade dispute between the EU and the US framed in a certain way. As we detail in our paper, this is not just about big tech not being able to access European markets. Digitization in the economy has made it so that essentially, I don't know, every firm or some substantial portion of firms on both sides of the Atlantic are tied into the data economy. So you're not going to just be seeing it impossible for having Facebook working between the EU and the US, or Google working between the EU and US. It's going to be a lot of different firms that have data operations that are sourced in different countries. So this gets back to my point on why I'm optimistic. I think the EU is essentially a friendly and willing trade partner. I have to believe that they understand the scope of the disruption that's going to be there, and there's going to be some willingness to try to go forward. Now, how you do that, that gets into the sticky areas of where the EU is willing to give ground and where it's not. There's some parties in the EU that are a lot more hardline. They think that the only way that you're going to see change is if the US changes its national security laws. And, I'll be honest, if the US did less spying on its own citizens and people abroad, personally, I would be very happy about that. How likely that is, particularly given how pervasive the spying apparatus is around the world. It's not just in the US. And this is not saying they do it too, but really literally every country is doing this to some degrees, and some are more public and more controlled, but there's lots of countries that have lots of trading policies that the EU will suddenly find itself increasingly isolated if it doesn't understand that there's some negotiation that's necessary on this point. And related to that, the EU, so going forward, how to go forward related to that, I think the EU is going to understand that it has to give some ground a little bit based on its trade commitments. So it has a treatment requirement so that it treats every trading partner it has on equal terms as it does with member states of the EU. The problem is under the EU fundamental laws, member states are allowed to run their national security as they see fit, and that's considered a competing right that can trump or not privacy, but it's not. Privacy rights cannot be an absolute trump on national security interests for EU member states. So I think that if you read that, and if you read the GATS obligations for the EU, they potentially are in a GATS violation situation if they are creating a de facto trade barrier between the United States and the EU or other countries in the EU. So I don't think the hardline approach is going to prevail in the long run, even if there's some people who want to push that, just because I just don't think it's legally tenable necessarily. So now, what are the changes? I think, if the EU has to give a little ground, I think the United States has to give ground too. Now, if we're not going to get laws through Congress, which I think anybody who would be in the mood to bet would not bet on a big legislative package coming through Congress, I think that there are potentially some changes that you could see at the executive level from the president through executive orders that could change the way our national security apparatus works in a way that will enable us to get an adequacy agreement with the EU. These are not my ideas. Theodore Christakis and Peter Swire have really offered some really interesting national security ideas. I encourage everybody to go and look at the work they've been doing. Theodore Christakis was talking about how under Section 702, the technical legal problem that the Schrems cases were based on, among other things, was that there wasn't an adequate right of redress for EU citizens. If the US was engaged in spying and they collected in signals analysis information on EU citizens, there wasn't a way for the EU citizens to get access to a process to figure out if that was fair and enforce their rights in a US court. So that's one problem that we had. Another problem we had is that the proportionality of the United States spying apparatus, national security tools were out of whack, were way too large relative to the potential needs for collection. So on the first one, I think that if Section 702 was tweaked with an executive order such that American firms were required to have full end-to-end encryption of data, such that signals analysis was no longer possible, that theoretically could frustrate the 12333 use of signals analysis. Theoretically, that might be a way to then have a change to the way the Section 702 process works in the FISC, so that an independent body works with the judges in the United States in order to give a right of redress for EU citizens. If that happens, potentially the EU might say that there now is an adequate right of redress. On the proportionality point, that one is a little bit more difficult. Essentially, it's more of an open-ended argument about what counts as a proportional need for a democratic society to have a national security apparatus. I think that if you then go back to what I was saying about how the EU has member states that engage in national security practices the same way the United States does, if you look at how there are different countries that they trade with without the same kind of adequacy agreements, if there's still trade with China, who undoubtedly does not protect rights as much as the EU and the US does, I think that the proportionality arguments can actually be advanced a little bit more strongly in courts. That said, I think it's going to be a bit of experimentation at this point.
So it's basically it's kind of a tough slog that actually requires some real focus from the Biden administration to get something done. What is your sense of what the prospects? Well, what is your sense about what the focus is on the U.S. in terms of actually getting things done at this point?
So, I mean, the political climate in the United States is not extremely friendly for the administration right now. There just is a series of unfortunate events over the last, say, 6 months. That said, if I was advising the president and I was looking at all of the different trade problems that have been faced by the US economy, from logistics to now the FAA disputes where you're having international travel is going to be disrupted, you do not need another disruption to trade right now. I would advise him that to the extent possible, I would make concessions to the EU. If the EU is willing to have some negotiation on this point, I would give them the concessions necessary in order to put some constraints on the national security apparatus in order to make sure this does not become another explosion
Another
on
problem.
the trade front. Yeah.
So Jose, do you think that the scenario that Christian outlines is actually feasible from the European point of view, or has this ship already sailed?
A couple of points of agreement and disagreement. I mean, first of all, I would absolutely agree with Christian that we are, from a perspective of both privacy and diplomacy, we are in a little bit of a corner here, simply because we have addressed, well, the large US platforms, but the fact is, if you're looking at the legal basis for transfer, for Christian, you mentioned China, is exactly the same. I mean, 1/5 of all European citizens use TikTok, and we can probably assume that at least some level of metadata is hosted in China, and we are currently using Zoom, and I will be very, very surprised at least some slice or layer of the personal information is disappearing to People's Republic of China. And if you want to talk about judicial redress, yeah, I mean, it is true that, you know, Christian, you said that everybody has some form of SIGINT, and that's true as well. My standard joke is that even Luxembourg has a signal intelligence agency, and it's a little bit like underwear. You know, everyone has them, but you're not supposed to show them off. I would have a slightly different interpretation of the national security exception that applies within the EU, but that's, you know, that's a realm of, you know, technicality that we don't have to deal with here. But the fundamental point here, I think, is a two-dimensional. One is that, yes, there are other cases than the United States. And also one thing that GDPR does, and many other laws, by the way, including US Cloud Act, it looks too much on the extraterritorial aspect. It looks too much on the transfer that actually data disappears out of your jurisdiction. The problem we have with most intelligence laws on the planet right now, including Cloud Act, as well as China's national intelligence law, is that you don't need to transfer. You can actually access the data inside the EU territory, meaning that you have to really distinguish national security and privacy. You can't conflate these two. One is not a silver bullet. If you think US signal intelligence is a deep problem, and or Chinese for that matter, you're not going to solve everything through privacy and stopping transfer.
Through data localization is not a solution to the national security issue, is what you're saying.
I wouldn't go as far as saying that GDPR is data localizing. It has certainly some of that effect, but yes, you can still take data out of Europe, and there are just some conditions to that flow, which is fairly, I mean, let's face it, it's not that impossible to comply with. We have much harder conditions and much firmer performance requirement that has been put in place. So with that said, and also Christian, I think you also pointed out a very good point that yes, we do have signal intelligence activities in Europe. As I said, the analogy of underwear, etc. And this conflict between, let's say, single market law around privacy and the, well, this exception is going to be a problem. And from my personal point of view, I would even speculate that this is actually one of the reasons we have this debate around privacy right now, because we don't have a constitution in Europe, which means that all the institutional division of power is constantly evolving. And we do have a court, European Court of Justice, that has really, technically speaking, no real say on the issue of fundamental rights and, well, vertical horizontal rights as they are defined between state and the citizen. And one of the reasons why I think these cases are happening is not economic. It's not about protectionism. It's not even about politics, because I would argue that even if France and Germany wanted to pull the brake and say, hold on a second, we have second thought about GDPR, let's redo the whole thing, I don't think it would be possible, because it's no longer a political issue. It's a much more fundamental issue around how the legal system is actually constructed in the layer between the national and the EU law. And privacy and the US transfer is just one dimension to this. You probably see in the news around how the German Constitutional Court is looking upon the EU law. So this is actually a discussion that is happening. And the difference between the United States and Europe is that we don't deify our constitution. We don't even have one. That basically means that everyone, including the European Court of Justice, is actually a player with an agenda and a political compass.
So Jose, I mean, given what you've sort of laid out here, which basically suggests that things will keep proceeding along the same track, what do you think is going to be the consequences, say, when the Irish Data Protection Agency sort of comes down with this decision, if standard contractual clauses are invalidated, and the US and Europe and the EU have still not come to a decision, an agreement? I You've written about economic implications in the past. What would you sort of project going forward?
Well, if Christian is an optimist, I am I came from trade negotiations. I am a perennial pessimist, simply because pessimist in my old line of work used to be right. So I would say a couple of things. One is, first of all, that it's probably too late to go back on GDPR, obviously. And what we have seen so far is that its normative effect has been limited, but it's not zero. I mean, practically every democratic country right now, aside from US and a few other countries, impose some kind of conditions on external flows. I'm just looking at, well, US partners in East Asia, Japan and Korea notably, but also a number of other countries are looking at not necessarily GDPR models, but they do try to distinguish, let's say, a territorial dimension to data, if I put it that way, without going too far. So I think, in a sense, we have to live with the fact that the baseline has changed. There is no free flow, absolute free, as in no condition whatsoever, is probably a thing of the past, with or without Europe. This is a problem.
Isn't that weird? Okay, I have to kind of step in at this point. I mean, data almost by definition, it doesn't have, sort of putting national borders around data is conceptually problematic, speaking as an economist and not speaking as a trade negotiator or a lawyer, right? I mean, I spent a lot of time studying the economics of data, and the fact is that the way that networks are set up is basically data is duplicated, right? If
maybe that's a part of the let's say cultural differences here, because you're now talking about the data object, whereas a privacy lawyer would probably look at data subject and also the jurisdictional aspect. So where is the data actually, under which law is the data?
For rights vindicated.
Yeah, right. And this is actually one of the biggest problems that you can't square. And I would argue that most privacy lawyers, even the most sort of the most ardent ones in Europe, would agree that this is, GDPR is not perfect, but this was the only way to square that circle. The less sort of pessimistic approach I would have is perhaps a reaction on something else that was brought up around is it possible to challenge GDPR and similar conditions under GATS? I would say probably no. I draw a completely different conclusion on that. I mean, this is a different discussion, but can we argue Article 14C exceptions for GDPR and the necessity criteria? I would argue probably yes. But it also depends on some of the aspect that, Michael, you were talking about, and Christian, you mentioned as well. If we only go after companies that rhymes with noodle or named after major Latin American rivers, we may end up in a problem. Yes, I mean, that's a de facto. De jure, it will be very hard to, argue that we don't actually the two-tier test under GATS. And also the question is that really desirable to go after GDPR? I'm just thinking out loud. I mean,
this is good.
I mean, this is a big question, because if you look at, for example, China's PIPA, and you have GDPR, you basically have GDPR as in you have the need for explicit consent, but also you need the consent of the government to take data out. And so we can probably argue, I mean, this is something that I also faced very much during, not just in the recent e-commerce negotiations in the JSI, but also in the context of other previous negotiations, is that if we have the chance of bringing, let's say, India and China to the level of, let's say, EU, and say that, okay, please at least have one mechanism reasonably available to take data out of your country. I mean, we could probably retire happy and say that we've done our share for our generation. I mean, if we actually manage to lift the rest of the world to that level.
That's a really interesting question. Christian, you wanted to say something?
Yeah, I just wanted to make a distinction. So for Hosek, I think, all right, whether you think GDPR was a good idea or not, or would like it in your country, the debate over what we're talking about is not really over whether there should be a GDPR or not. I'm fine to allow the EU to have whatever regulatory state they want. If all the companies really like that regulatory state and they're happy doing that, fine. The issue is that GDPR is being intermixed with national security policy and trade policy in a way where I think it is erecting trade barriers, not because of GDPR per se, but because of the operation of the GDPR in conjunction with how the EU has construed national security policy for the United States. That's totally different. I don't think that what anybody in the US is asking for is to undo GDPR or not make US firms subject to GDPR if they want to trade in the EU zone. The issue is that there would be no trade possible if you have data, and Schrems goes to his logical conclusion is what we're seeing under these SECs. And I think that's different. And that's why I'm a little optimistic. I think if people in the EU start to recognize that and they're like, look, we're not trying to come for GDPR. If anything, I would put my money down on the US moving toward a GDPR style regulatory framework, much to my chagrin, in the future. So that's really what we're talking about, I think.
Let's talk a little bit about, we haven't talked about economic consequences yet. Okay. And Hosek has written about this in the past, and I've written about this. Okay. Whether or not if there was a data disruption, we would expect to see economic consequences. And I think this is actually a fascinating question, because I think in many ways that the global cross-border data system has sort of grown up in a way that relies on cross-border data flows for both efficiency and also for the ability to sort of transfer best practices from one country to another. So in some sense, if we cut off the flows, we would both have a diminution of efficiency and also a diminution of the ability for say improvements in the US or improvements in Europe to sort of affect other countries in a positive way. And so we're sort of not talking about a collapse of the global economy. We're actually talking about a slowdown in innovation, a slowdown in diffusion of innovation, a slowdown in cross-border, the ability of countries to sort of move on the same the same innovation frontier. And having said innovation frontier, I have to sort of point out that PPI has an innovation frontier project, and that there's a little plug for that. It's, go to the website. We have a lot of great papers there about, including some talking about diffusion of innovation. But so the losses from a slowdown in cross-border data flow, whether it's sort of be localization or something else, has to do with putting our resource, a loss of efficiency, because we're putting our resources into duplicating infrastructure, duplicating investment, and also making it harder to diffuse cross borders. What's your thought, either one of you? Hosek, what do you think?
Well, I'm starting to feel a little bit of devil's advocate here, because
go for it.
Yeah, I'm not sure if people in the amongst the participants actually know me, but I have written since 2012 about productivity losses and trade friction coming out of data barriers, and I've been screaming about it so loudly from the perspective of actually looking after Europe's competitiveness and our offensive interest, that I mean, certainly I've had my fair share of insults thrown at me from various type of data protectionists in Europe. I'm going to offer slightly a little bit more nuanced view today, for the sake of actually, because we are, as it seems, very like-minded on this issue, and especially when it comes to the economic importance of data. Which begins on the point that I said before, is that this is a cost, this is a loss that Europe has already accepted. And one of the most treacherous thing about productivity losses is that no politician needs to be accountable. No industrial planner needs to be accountable on day 1, 2, 3, or even in year 4. You don't see those effects until you actually bring the line at least 5-10 years forward. So in other words, when I was talking about regulatory compliance as a comparative advantage, yeah, that's in short term, but in long term, it's not going to work, especially if you have an economy like the United States that has an extremely higher degree of technological adaptation. And if you
let's actually just point out that the GDPR having gone into effect 4 years ago, we're kind of at the point where we would expect productivity losses to start actually showing up even as a long-term effect.
True, absolutely true. And also I think, and this point brings me to my second point, which is that I think this is also one of the reasons we have actually relatively light touch regulation coming into play, for example, on the upcoming AI Act, is surprisingly reasonable when it comes to liability, and I think this is a direct effect of GDPR, meaning that this is actually one that we can't screw up. So sorry for the choice of words. I'm not a native English speaker, so I can cuss as much as I like. In my
That's okay. I'm from New Jersey. That's like our language here.
Okay,
it's fine.
All right. So in other words, you see a softer approach coming, which is a little bit more risk-based, but that goes not, I mean, it's not without opposition. I mean, the European Parliament wants to actually pork barrel more into this and put more onerous obligations and hit at someone they like. But the Commission and the member states have been very careful to say, okay, if GDPR affected everybody, but you are going to actually just implement it on some of the worst transgressors who happen to be non-European, you are now in a position where we are really carefully looking and said, actually, this can be very costly. So for example, on general purpose technology like AI, we need to be really, really careful. We are less careful about Digital Markets Act, and that's where, for example, we have imposed thresholds to make sure that no European companies are affected. There you can talk about a potential WTO challenge. Is this really national treatment, MFN, or is it a de facto discrimination? That's for a separate, conversation. But I think we are still beginning to see that actually we can't afford to screw this up. I mean, United States has a 10% labor productivity advantage over Europe, which it has enjoyed more or less for the last 20 or so years, even longer, and which is 100% attributable to actually a faster adoption of internet technology and some various form of network technology. That goes absolutely without saying.
See, for exactly the reasons that you're saying, Hosek, I'm actually less concerned about the impact on Europe and more concerned about the impact on the US. Because partly we have to think about, is the US willing to sort of focus, as Christian discussed, is the US willing to make concessions at this point, actually focus on this issue? And part of what would have us focus is the economic implications. And the US has had a very dynamic tech sector in terms of high investment. And what has been supporting a lot of this investment is actually the global nature of the US tech sector and a lot of, in effect, exports of data services, which don't show up really clearly on the data. I mean, I've sort of written about that. There's reasons why it doesn't. But the way that we sort of calculate exports is we actually look at amounts of money paid by foreign persons to US persons. And if in fact the money is being paid to overseas subsidiaries, it doesn't actually show up as exports. But in fact it is, because it is supporting US investment and US jobs. And we may discover that the economic implications for the US are actually fairly large, and not just on the productivity side, but on the job side as well. Christian, do you want to say something?
Yeah, no, I think that's right. On the economic efficiency of, or lack thereof, of data localization policies, I think to some extent it's a cost that a society is willing to absorb. So if the EU wants to impose data transfer requirements and their society is willing to absorb those costs, I mean, I don't know. I don't think it's worthwhile personally, but that's their decision. I think that there's a distinction, though, to be made between, so to go back to something Hosek was saying earlier on why we have data protection laws. In order to have rights of redress or have the vindication of rights for citizens, you can have the vindication of rights for citizens without having hard data localization requirements that require redundancy of infrastructure and data. As long as someone can seek redress in a court for, or whatever regulatory process is in place in a particular state for a harm that they suffered, that's really what matters. It doesn't matter if the data is on a server in Brussels or in New York City. It matters if the firm is reachable. So if you're doing business in the EU, you need to be able to answer to EU legal requirements and serve the interests of the EU citizens. It should not matter if your infrastructure, if you're running a safe system and you're storing it where, wherever you're storing it, that really should not be central to the law, in my opinion. And I think that gets to what Michael's saying, that we're unnecessarily adding those costs to the economy that are going to hit both the EU and the US. And they're not actually furthering, in my opinion, necessarily the rights of the citizens. And at the same time we're doing this, there are competitive threats from countries like China that don't have exactly the same level of legal background that or legal commitment that the EU and the US has to the way it runs its economic and legal affairs. So while the EU and US, who are supposed to be and are natural trade partners, we have very compatible systems, we have very compatible values. While we're squabbling over this kind of stuff, I think we're really losing ground for the future on economic competitiveness.
Can I just briefly come in here, Michael?
Please
I
do.
think Christian is making a great point, and I would like to also engage in shameless self-promotion.
Go, please do.
Yeah.
Everybody needs to. I've already done it. Okay, we're going to let Christian do
Now,
it too.
I just compare the U.S. laws versus Chinese laws as an example, and obviously under Chinese law, according to the Chinese constitution, a foreigner doesn't even have a legal standing in front of its courts. And you can imagine it's almost rhetorical at this stage. What kind of rights would you have challenging national intelligence law as a European subject, or even worse, as a Chinese data processor who's being asked to grant data access on European citizens' data? Obviously, this is not even academic. It's farcical. Here's where I think that the biggest problem lies, and you can also see that as a problem from the perspective of the United States, but also you can also see that as a potential next step, which is that when PRISM was revealed in 2011 with all the upstream data collection, XKey, Blarney, and all these programs. The one thing that we did was that we demanded negotiation to scale back these practices. We asked for Judicial Redress Act. We also demanded considerable parliamentary oversight of the intelligence activity even under ex parte, some kind of court procedures that was tangible. We got that from President Obama. The fact that we don't actually ask for it when China introduced a national intelligence law in 2018 entails probably that either we trust President Xi more than President Obama, or we have some alternative means for judicial redress, or we believe that Chinese Public Bureau of Security is so benevolent they would never ever spy on Europeans because we are so uninteresting. One of them has to be true, right? So, Christian, you said, one of the problems that we conflate national security and the privacy. I would argue to a certain extent that the opposite is true. We don't conflate those because we don't have an alternative left-hand. We can only negotiate things as a privacy matter unless we have an incident, unless there is a smoking gun. I would argue that national intelligence law is not a smoking gun, it's a loaded gun. You can use it anytime, but we can't negotiate over it And hence we took a completely different approach, for example, with addressing Huawei. We were playing with a high-risk vendor paradigm rather than the privacy paradigm of cybersecurity, because there was no other legal basis to address the problem within the structures of EU law. I don't think this holds. At some point, people will start to ask questions, especially as TikTok and Didi is becoming extremely successful. Zoom, that we are using now, is another example. At some point, people need to ask themselves that question. And this is not just for the regulator to answer. I mean, Michael, you mentioned the example of Schrems from the very, very beginning of this conversation. His NGO, NOYB, who's actually raising these pro bono cases in various jurisdictions all over Europe. He has raised 101 cases for GDPR violations, exactly against, well, US companies, and specifically just Google and Facebook, I believe. Not a single case has been raised against Zoom or TikTok or any other Chinese entity that is subject to national intelligence law. Somebody, not me, but somebody needs to answer the question, how is that a tenable policy even from an NGO? You have a lot of explanation to that, not you personally, but there are people in Europe that needs to do a lot of explaining.
That's a very interesting point. So let me, I mean, that's almost the elephant in the room here, right? Because if we sort of keep taking steps back about what's going on here, framing it that way for US politicians and policymakers starts making more sense. Okay, because it's easier to sort of find bipartisan consent in some sense in the US around policy towards China than it is towards almost anything else. And to the degree to which this turns into a discussion about should the US and the EU, on the basis of their many commonalities, kind of, I won't say band together, but sort of approach each other in a much more friendly fashion on this, becomes politically and economically a much more tenable approach in terms of US politics. So I actually think that this, I mean, let me ask, for anybody listening, if you have any questions or comments, please put it into the chat box. Okay. Let's kind of sort of do a final roundup here. Christian, is there anything else you'd like to sort of add to the current discussion?
I appreciate Hosik's comments on the trade issues. They're fairly complicated, and I'm not selling my view as 100% the way to go. I still think that there's some room there that the US could at least use as a way for, basically what I'm trying to figure out is a way for US negotiators to talk to EU counterparties as a way of saying, well, look, here's like a legal requirement you have to comply with, to give the EU a foothold, so that if they do need to modify their position, they can do it within the framework of their laws. That's essentially, I think, where the US negotiators need to come down, because the EU is pretty dug in on GDPR. And I don't think the US, and I don't think they do, and I don't think they should have the position of saying you need to get rid of GDPR. I completely agree. That's not going anywhere. What we instead need to do is figure out ways that there can be some room for the EU to understand that it does need to treat us like a partner. We need to change. They need to be open to the fact that we both can go forward together.
Thank you. Hosik, let's just point out that Hosik just put in his take on US and China versus China law into the chat box if people are interested. So a final set of words.
Well, if I was going to advise both sides, I would say that to the United States, I would say Europe has that national security privacy D-link. We are a little bit tone deaf in that sense. It's almost like we have no tentacles out there, and we are almost single-mindedly focused on privacy, because these are the people you're talking to. To make the matter of things worse, you're actually proxy negotiating with a court, which has its own institutional agenda. And until we have a treaty change and which might come out horribly right or horribly wrong, depending on what your politics are, you are not going to see any scale down of these ambitions internally within the EU. If this was just about economic/politics, it would be easy. It's not. That's what I'm saying. This is completely politically dealing, but that makes it very difficult to negotiate. The other advice I would give to the other side, to the EU, is that we have a tendency to believe that Americans, especially Democrats, secretly want to be French or Scandinavian. Americans are Americans, and they have their own national interest, and the core interests of the United States are usually bipartisan and non-negotiable. And meaning that whether you're talking about carbon border adjustments or if you're talking about privacy, Europe found its own way, and United States will do so too, that fits its own regulatory tradition, its own stakeholders, et cetera, to expect that if we push, or if we basically dig our heels down, United States will come closer to our edge. That's not necessarily the case. So I think, yeah, I mean, we all want the same thing. We want to have a reasonable compromise against a reality where some condition, some more onerous than others, have become or are becoming increasingly the norm. When we're talking about banding together against China, I'm not really sure to what extent that is feasible, but there is a China problem, that's for sure. And I spoke of how we have not dealt with the China problem in the same way that we have dealt with the Silicon Valley problem. And for me, that is a clear case of either discrimination or over-trust in the Chinese system, depending on what your politics are. But in the case, I think also of the United States, we have to bear in mind that, you know, if you don't have a privacy discipline, if you don't have a European model, dealing with, for example, a situation like TikTok that is harvesting data out of US citizens is going to be extremely problematic. And solutions that we saw under the previous presidency show that they are not even legally viable. And so that means that there is going to be a huge strategic vulnerability, if you so like, of the one-way street. And this is something that I actually admire United States for, do the walk and talk the talk. And, so if you're for, free data flows, you invite China to say, please take my data away. The issue is actually the fact that I can't take your data back to mine. That is admirable. I'm just asking myself, how tenable is that position over time if that goes on for too long? And if you look at the attempts of the previous administration, I would say that they are not exactly legally elegant. And it was so because there were no other options, probably. But I defer that to an expert in US law.
Yeah. Well, thank you very much, Josek, for participating in this webinar. Thank you very much, Christian. I think the thing that I come away with from is that this is a very live problem that's going to sort of reach up and sort of bite us at the moment that we least expect it. This is perhaps the lull before the storm, while we still have the standard contractual clauses in functioning. And it's kind of being, the data flows are being nibbled around the edges, and then we may unfortunately find out what the economic impact really is of cutting back on cross-transatlantic data flows, what the great transatlantic disruption will bring. So thank you
Michael,
very much.
Can I just disrupt you for a second, because I think we have a question. Someone is raising her hand.
Let's see.
I believe it's Annette.
Let's see. I'm not seeing what the question is. Can the person put the question into the chat screen? How do I get the question?
She's raising her hand at least. Sorry, I interrupted, but
no, that's good.
Can you unmute Annette?
I did the Q&A. I didn't see, I didn't.
She took her hand down, so we lost her chance.
Oh.
We lost, we
Sorry
lost.
about
we
Oh, well,
lost- we
sorry,
lost
Annette,
it.
next time.
If you could put your question into either the chat box or the Q&A, we can sort of deal with it. But give you a moment because we're always in favor of questions. Sorry, this is our basis of our data disruption here. Okay, so it's apparently it's turned into a one-way street. We would like to answer your question, but we can't. And so, do you have any thoughts about this? No. Okay, so feel free to sort of email one of us with the questions, and appreciate both of you for being on this. Please take a look at our paper on either the PPI or the ICLE website and the Great Transatlantic Data Disruption. And thank you very much for being here today.
Thanks, guys.
Thank you, guys. This has been great. Enjoy the talk.
Absolutely.
And congrats to the paper.
Thank
Thank you.